All right, welcome everyone. My name is Patrick McHugh. I'm president of the DC chapter of the Labor and Employment Relations Association and associate professor at George Washington University. I want to welcome everyone to today's or tonight's webinar, I guess. Each local LERA chapter is unique. Being in DC, our comparative advantage lies in our governing board having diplomatic members representing 7 different countries, and our focus on public policy and the regulatory issues related to the employment relationship. Given our focus on public policy, the DC LERA chapter is very excited to host this conversation with Wilma Liebman. If you've got any questions during our session, if you could type those into the chat, and at the end of our session, we'll have some time for Q&A and hopefully address some of those questions. I want to give some special thanks to Emily Smith and Bernadette at National LERA for their assistance in coordinating this event. Our moderator tonight is going to be Steve Sleigh, who will be introducing Wilma. So Steve, I'll turn to you.
Thanks a lot, Patrick. And Wilma and I are going to take the headphones off and now just have a conversation. And Patrick, if we seem to be going amiss, text me and I'll get that info. So. But thank you for joining us, Wilma. It's a first of the presentations that we've done in a studio. So we're testing it out and see how it works. But we're at the Switch and Board podcast studio here in Washington, D.C., appropriately distanced. So please, everyone, be aware that we're masked up and appropriately distanced. It's a safe environment here. I am Steve Sleigh. I'm the incoming president of DC LERA. There was an earlier notice saying that Wilma is the incoming DC LERA president. She's not. I am. We're one of 40 or so chapters of the National LERA, of which Wilma is the incoming president in 2021. I come out of the Machinist Union and first met Wilma actually when I was working for the Teamsters in 1994, I believe it was. We were doing trying to mediate a strike between the Teamsters and the National Master Freight companies, and Wilma was working at the FMCS. But we are incredibly fortunate to have Wilma with us today for a kind of an informal conversation. We shouldn't have a formal presentation, but we're going to have a conversation about careers in labor and issues in labor law and what she sees in the next administration for labor policy, and importantly, what LERA National, her plans are for as the president coming in. So without further ado, let's just kick it off. And Wilma, why don't you just tell us a little bit about your extraordinary history? It goes back many years in working both in unions and in public service.
Well, thank you very much, Steve. You were modest in not saying that you are a past president of National LERA. So I'm following in your footsteps. It's a pleasure to be here this evening, and thank everyone in our audience for coming here. I have had a long career. It's kind of startling when you realize how many years. I started my career out of law school working for the NLRB here in Washington in the Division of Advice. Then I spent a couple of years in the Oakland, California region. Then I came back to Washington in 1980 and went to work for the Teamsters Union in the legal department. I spent 9 years there. I had a very brief stint in a private firm, primarily working representing the International Transport Federation Maritime Division in a campaign they had for flags of convenience on behalf of seafarers. And then I went to the Bricklayers Union, where I spent about 3.5 years in the legal department. And then at the beginning of the Clinton administration, I went to the Federal Mediation and Conciliation Service, where I became the deputy director. We were involved at that time in the big Teamster strike against the trucking industry, and also later a big strike against United Parcel Service. There was also a brief involvement with the baseball strike, as you may recall. And then in 1997, when there was an opening or a vacancy on the National Labor Relations Board, I was nominated by President Clinton and appointed and confirmed by the Senate to a seat on the board. I was part of a 4-person package, 2 Democrats, 2 Republicans. Back at that time, the Senate did packaging of nominees. And I went on to serve 3 terms at the NLRB. I was the 3rd longest member of the NLRB in its 80 plus years history. So I was appointed first by President Clinton, twice by President Bush, and named chairman by President Obama on his first inauguration day. So I spent nearly 14 years there through Democratic and Republican administrations. I wrote a lot of dissenting opinions during the Bush years. And also the board is supposed to be a 5-member board, but it was noted for long periods of vacancies. So I always say that I served on 5-member boards, 4-member boards, 3-member boards, a 27-month 2-member board, and I even spent 6 weeks by myself. So I saw it from all sides. And then at the end of my 3rd term, I stepped down in August 2011. And since then, I have been extremely fortunate in the range of things I've gotten to do. I call myself a gig economy worker. I've taught at a variety of law schools, most recently NYU Law School, where I taught both traditional labor law and 3 times taught a seminar called Regulating Work Beyond Employment. I've also had the good fortune to work with the UAW and the IG Metall in connection with their efforts to organize the Volkswagen plant in Chattanooga, Tennessee, and form a works council. So far, an unsuccessful campaign, but hope springs eternal, I guess. I worked in the early days of the Fight 15 on helping to put together their joint employer theory. I've done some work with a research group, a multidisciplinary research group, studying the franchise business model in the fast food industry. I've had the good fortune to work with some academics interested in worker ownership possibilities, and I'm currently working with a group out of the New School on digital platform cooperatives. I've also had a dispute resolution role since 2013. It's a permanent dispute resolution body that is part of the collective bargaining agreement between the Farm Labor Organizing Committee and the North Carolina Growers Association, which represents about 700 growers. They bring in about 9,000 or 10,000 H-2A farm workers every year. And I've also gotten to work over the course of about the last 10 years with a European business group that was put together to help multinational companies comply with the European Union Works Council directives. Their members are mostly American multinationals, and obviously for them, the whole idea of works councils is a little bit foreign. So again, I've been very fortunate in the wide range of issues I've gotten to work on.
Yeah, incredible, just amazing. And I remember back in those days in 1994 with the freight strike, it went on, and you and the director John Wells did a great job of bringing the parties together. Talk a little bit about being in public service. You know, it must have been frustrating to see the board sort of get whittled down and somewhat marginalized in these critical issues about labor and management and how to enforce the labor regime that we have.
Yes, very frustrating. So first of all, I guess I would say, particularly for young people who might be on this webinar and interested in a career in government, that government service definitely has its rewards. It's for those who are lawyers, it's a great place to learn the law, the substantive law. It's a great place to learn how the law works, about the processes of the rule of law. It has great satisfaction to work in the public service, and also the friends you meet in government really stay with you for a long time. But certainly, especially in the last 20 years or so, there have been enormous frustrations given the deep divides in our society over the role of government, with anti-government dogma growing in prevalence. During my period, particularly as chair of the NLRB, just from January 2009 until I left, we were subject to what I called a record accumulation of difficulties, with tremendous rancor directed at the board because of its activities, the board's activities, the general counsel's activities. There was a complaint that was brought against the Boeing Corporation that you probably remember, that generated a huge amount of controversy, and there was constant congressional oversight, demand for production of documents. Also, people will remember that at the beginning of the Obama administration, there was great hope for labor law reform and the Employee Free Choice Act, and that hope was quickly dashed. The first priority of the Obama administration was healthcare, and by the time that was concluded, Senator Ted Kennedy had died, the Tea Party had formed, and the chances of passing the Employee Free Choice Act seemed to vanish. There was also an enormous controversy over the nomination of one board member, Craig Becker, who there was a threatened filibuster over his nomination. He never was confirmed. He had only a recess appointment. And so the controversy during that period was really quite extraordinary. The rhetoric about the board and what it was doing quite hyperbolized. I used to say that we existed in a climate where there were efforts to distract and discredit the board, to defund and defang the board. Nonetheless, despite these challenges, and so there are persistent challenges, it's an aging statute, a 1935 New Deal statute that has not been significantly amended since 1947, despite several attempts at labor law reform that all ended in congressional impasse. So we're dealing with an aging statute with decades of precedent that has to be navigated, with a sometimes skeptical, if not hostile, judiciary, with an enormously changed workplace, economy, and society since the days when the law was enacted in 1947, needless to say. And today, of course, now we're dealing with the challenges posed by the health crisis, the economic crisis, the racial justice crisis, the democracy crisis, et cetera. So there are enormous tensions and challenges to applying this law in a meaningful way. How do you keep the law vital? There are modest but meaningful steps you can take, but radical change, I don't mean radical in a right-left sense, but major change or transformation in labor law would certainly take legislative action, because even a board that was committed to a dynamic interpretation of the law is limited in what it can do by the existing law.
Yeah. So a couple of the issues, and we could spend hours on any of those topics, and it's distressing, but also enlightening that the battle over labor law and labor policy isn't new. It's been ongoing, and the National Labor Relations Act really is in critical condition and sort of out of step with the reality in the workplace for most folks. So there's a couple of issues that just want to talk about in a little more detail. One is the whole notion of the gig worker and the non-traditional worker, the independent contractor. We just saw in California a huge, expensive fight over the classification, and Uber and Lyft spent, I don't know how much, $100 million or so. 200 million.
or more.
or more, right? So it was just a huge effort to institutionalize the misclassification of workers. So that's one issue just to talk about. But the other one is, and closely related to that, which is about technology. Uber and Lyft are a function of a new technology, these apps that can take the place of a manager and a dispatch operator. Our colleague Tom Koken and the folks up at MIT just did a report that just came out on the future of work. I think we're going to have that posted to our webpage, so people should definitely go on that and take a look at it. But it really is these two issues of the misclassification of workers, or maybe that's the wrong way to say it, but the inadequacy of our labor law framework for dealing with employment issues today. That's the one issue. And then the related issue of technology. So I know you've worked on these issues a lot. So if you could talk about those.
Thanks. So one thing I left out of my post-NLRB life was a study that I was asked to contribute to by a German labor law institute. And they published a study of crowd work platforms in 2016 with contributions by myself representing the US and a German and a Japanese academic. When I was asked to do this study, I barely knew what crowd work was, but I educated myself in these platforms that engage a global workforce. Unlike Uber and Lyft, although you get work off of a digital platform, you don't work in a local labor market. You're working virtually with the whole range of issues that virtual working in isolation, sometimes anonymously, creates. So they're the platforms that might be known: Amazon Mechanical Turk, Upwork, which is a huge freelance platform for freelance projects, and then what are called open innovation platforms, which operate usually by competition model. So corporations looking to answer a complicated R&D question would put something out for competition. But so we analyze these platforms in terms of whether the people who work on them would be considered employees or independent contractors under existing laws. And they're all treated as independent contractors, certainly for the most part. But what it does highlight, and this, I should say that this was at the same time that the litigation against Uber and Lyft was really beginning to heat up. And what it did was to highlight issues that have existed for decades, namely the exclusion from the labor law of people who are considered independent contractors. And even when I was on the board, I often wrote dissenting opinions about what should be the proper factors that you can look at under the National Labor Relations Act. So this is, if there's anything positive that's come out of Uber, besides, I guess some people like it for rides, it has been the attention that has been brought on the inadequacy of the labor laws to these exclusions, and people who are treating people who are not really independent business people, but are really quite dependent on these platforms. So I think Prop 22 is an interesting one because it raises the possibilities, and I don't know if this is going to happen or not, but I know discussions have been ongoing in New York and California about the possibility of creating carve-outs for those platforms that would engage in some kind of collective bargaining with the workers. So, for example, one notion is that they could treat the workers as independent contractors if they also engaged in some kind of collective bargaining. I think what's being discussed is in the nature of sectoral bargaining. My understanding is the unions are somewhat split. Some are open to discussing this. Some, I think, are probably a little skeptical. Apparently, Lyft is expressing a willingness to engage in this kind of conversation. Interestingly enough, I'm almost at a deadline for a law review article I agreed to co-author on the subject of collective bargaining and the self-employed. Wow. For a comparative labor law journal. And I'm authoring it with Cindy Estlin, who was my co-teacher at NYU Law School. In this course, we taught on regulating work beyond employment. So lots of interesting issues percolating, a lot of, I think, dynamic thinking. The other piece of what you asked, of course, is about technology. And technology, of course, has created these apps and these kind of different work opportunities, but technology poses different issues in the workplace. And I think some of them could easily crop up in NLRB cases. So, for example, the duty to bargain over the institution of new technologies, automation, robots, AI, et cetera. There is not a whole lot of board law specifically on that. Unite here in the hotel industry have entered into some pretty interesting contracts requiring bargaining for a certain period of time over the introduction of new technologies, but whether there's a duty to bargain has not specifically really been answered. I think there should be a duty, but the law is somewhat open. Other issues would be, and I've talked to a few reporters over the last 6 months over, I think Amazon or Whole Foods has been using new technologies or new software to record and monitor employees' collective action, probably looking for the beginnings of union activity, but other kind of collective action as well. And issues that raises of surveillance or perhaps coercive monitoring under the National Labor Relations Act. And the other interesting issue was really posed by the Google strike of a couple of years ago. And there are several other instances that I've seen of workers who are engaging in collective action, either striking or other kind of protests over the use of certain technology. So Google, for example, had its Project Maven with the Pentagon to engage in, I guess, surveillance of drone activity through artificial intelligence, and there was big protest movement about that. Similarly, Project Dragonfly with the Chinese government to build a censored browsers, and there was a big employee protest and uprising over that. And so I don't think these actually came to the NLRB, but I could envision cases like this which came to the NLRB testing the question of whether this was protected concerted activity under the labor law. So lots of different angles to technology and changing technology.
Absolutely. No, and a fascinating time. So maybe that's a good place to sort of pivot to new administration coming in. January 20th, 2021, we'll have Joe Biden sworn in and Kamala Harris in a new board representative chair, I presume. I don't think John is going to stick around, but just as you're looking at 2021 and beyond in terms of, if you could set the agenda for the issues for the board and for labor and management, quite frankly, to be thinking about, what are some of the things that you think are sort of both specifically on the docket and more generally, how can we get beyond the framework that we have of an industrial model that was adopted in 1935?
Boy, you just asked me a lot of questions. How much time do we have? So I think it's important just to I'll try to say this very quickly, that the first issue that facing the board, of course, will be appointments. At the moment, the board has 4 members, 3 Republicans, 1 Democrat. There's 1 Democratic seat. Presumably the 1 Democrat would be named chairman at the beginning, but she wouldn't have a majority. And then the next Republican or the next vacancy will be next August. So at least until August, there will still remain a Republican majority on the board itself. There also is a Republican general counsel whose term, as I understand, or as I recall, goes for another year till November 2021. And so there is a question of how quickly a new Biden majority board can act to, what I would say, both undo what's been done, the damage that's been done during the Trump years to worker rights, the erosion of standards and rights, and to begin to repair. This period is not the usual kind of pendulum swing that the board is famous for. The board is famous for whether you call it flip-flopping or policy oscillation, because I think the changes that have occurred over the last 4 years have been so rapid and extensive, both through case decision-making and rulemaking, very extensive use of rulemaking that was not the case before at the board. So it will take some time. There is talk, I don't know where it stands, I speak only for myself, that was raised by a decision of the Supreme Court this summer involving the Consumer Finance Protection Board of the president being allowed to replace the head of a unified agency that's different from a multi-member board. And so the question is whether that would apply to the NLRB General Counsel, who is an independent prosecutor, doesn't act at the behest of the multi-member commissioner of the board. So that's the first question about when will a new Biden board majority and general counsel be able to start taking action? It will face undoing some of the Trump precedent. I think that could easily take 4 years, let alone just to get back to the end of the Obama years, let alone move ahead. Obviously, when cases come before the board, or unfair labor practices come before the board, they get there only because the general counsel has issued a complaint, unless there are representation cases. And so that's another way that cases get to the board, if there are union organizing efforts that where the unions are seeking an election. And so that does not go through the general counsel. There is also the option of rulemaking, which the board could certainly do. It is a very time-consuming, labor-intensive process. So we're talking some time before issues. A more transformative kind of labor law effort, I think, would have to await congressional action. And whether the Senate ends up as 50-50 or not, I think a significant labor law reform effort probably not in the cards. I'd like to be surprised.
Yeah.
I would love to see an opening for a really constructive dialogue about significant, comprehensive labor law reform, and one that took into account strengthening the current collective bargaining system, but supplementing it. And so another article that I've written in the last couple of years went back and looked 100 years ago at what was then called the labor question and the various different views of what constituted industrial democracy. And people seem to agree that industrial democracy was the answer to the labor question, but what industrial democracy meant was subject to different interpretations. And to very, very quickly summarize what was talked about. So you had the collective bargaining model that was favored by the American Federation of Labor. You had various kind of worker ownership initiatives that were favored by the Knights of Labor and some other organizations. Employers, for their part, were interested in industrial democracy, but they weren't particularly interested in independent trade unions. And many of them fostered works council type organizations in this period of welfare capitalism. So all of these things, interestingly enough, are percolating again. People are talking about works councils. I think people have been looking at the idea of works councils for some time, but I think the experiment at Volkswagen really sort of catalyzed the discussion again. People are looking at not only works councils, but the other part of German co-determination, namely worker representation on corporate boards. There were several bills introduced in Congress that would have provided for some form of worker representation on corporate boards. Worker ownership efforts are picking up again. I think you've been involved in some, Steve. As I mentioned, there's a initiative out of the New School that's looking at worker-owned digital platforms. So I think there's enormous dynamism of thought and action. And I guess what I would add to that, in the last 7-8 years, we've seen a surge of worker mobilism and mobilization and activism that we haven't seen for decades. So I think that there is a lot of interesting, innovative thought and action going on. Unfortunately, the pandemic interfered and I don't think stopped that innovation and that dynamism, but it certainly kind of changed course. What it did do was to expose the inadequacies in the law, how our social contract has broken down over the last few decades. It exposed all that in bright lights.
Yeah. Were you surprised that there was relief put in there for gig workers? I mean, that was first of its kind, where unemployment benefits were extended to independent contractors. Were you surprised that that
Yeah,
went through as easily as it did?
I was.
Yeah.
I understand that Uber and Lyft, maybe DoorDash, are looking at Prop 22 as a model to try to take around the country, maybe even take to the federal government. I think it remains to be seen what success they have with that, certainly at the federal level. But some would say that these gig workers, or a lot of people are gig workers, but these platform workers like Uber and Lyft should be not treated than any other workers. But I think there is room for experimentation and different ideas, particularly given how long litigation takes to prove someone is misclassified.
Yeah. It would seem to me that there are some opportunities to work with the business community on some of these issues. We had a great presentation back in the before the pandemic by Eric Dean, the president of the Iron Workers Union, and he talked a lot about training and how the union really sees itself as the one that is providing key resources to the industry, which is skilled workers. If you think back to the Clinton days, and there was a major effort to do labor law reform that John Dunlop actually headed up. I believe he was the guy that was brought in to say, we've done it before, let's do it again. Sort of think back on what went wrong with that effort, and are there ways that you could see that to make sort of rethinking our labor law more palatable to the business community?
I would love to see a dialogue between labor and business. I am sometimes very disappointed that just doesn't seem to happen. I think there probably are portions of the business community that would be willing to engage in such a debate and have ideas about it, but it just doesn't seem to happen. And what you hear more loudly, of course, is the rancor and the anti-unionism. So I think with the Dunlop Commission, their recommendations were dead on arrival. And Congress has just been divided on these issues for so long. I mean, labor law has been controversial from day one, and it's always been subject to these deeply held and divided views, which I think are emblematic in some ways of the broader divides in our society, particularly on the role of government. But I would love to see, maybe even starting at the local level, labor management committees come together. They could be tripartite with government, labor, and business to come together to try to address some of the problems that we are now facing, particularly with the economic collapse that has happened. Whether that will happen, I don't know if there's an opening right now. I was thinking earlier today that we are suffering from a crisis of worker voice and worker power. And Trump himself said that at the beginning, I'll be your voice. Now, I don't think his administration followed through in being pro-worker. But it acknowledged an underlying problem. I think there are probably some openings with the minimum wage. I think it's become quite obvious that stagnant wages have not been good for our society. The inequality that's resulted from decades of stagnant wages has certainly been bad for our society. And I would like to think that responsible parts of the business community are aware of this and are aware of the dangers if we don't address these problems. The Business Roundtable last year did its revised value statement about the importance of stakeholder, but I don't know that it's translated into anything yet. And I don't think it can be addressed simply by enlightened corporations doing corporate social responsibility. There is a role for government here. And if there was a way for labor and business to somehow come together to address these issues, I would say that would be great. LERA is a forum in some ways, which brings together its unique advantage in that it's not only multidisciplinary, but brings together people from labor, from business, in academia, in the workplace, the neutral dispute resolvers, the public policy makers, the people in the media and the communications and the public discourse. So there's all these different skills and expertise and knowledge and experience within LERA. A great place to have a debate about some of these issues, to explore these issues, to debate them, to find better ways forward. But I don't see it happening on the national stage. And I guess a lot will turn on what the Republicans in Congress are willing to do. And I'm just not that hopeful.
Yeah, I'm not that hopeful either. But it was interesting, the restatement of the Business Roundtable to acknowledge stakeholders. They very carefully avoided mentioning unions and actually collective bargaining or worker voice, but it is an opening, and it does seem like there's an opportunity to actually say that there's more than just shareholder value at stake. And in my experience working on the private equity side, the smart folks in private equity have figured out that working with stakeholders actually is the value proposition that makes the most money and makes the most long-term sustainable investments. But it's another topic for another day. I want you just to talk for a minute or two about baseball. So you were there in the 1995 strike, which was cataclysmic for baseball. Took them years to recover from that. Their collective bargaining agreement is expiring at the end of this season coming up. So if you were to put on your FMCS hat, what would you be, how do you sort of see these kind of high profile labor disputes?
Wow. You didn't give me notice you wanted to talk about sports. I have to tell you, I always get myself in trouble when I talk about sports because I know nothing.
Well, we have in December, we have our presentation is on sports and bargaining. So,
I see.
Yeah. So this is sort of a tee up for our December conversation.
Got it. And I guess I should say honestly that I think the FMCS was involved in that baseball strike for about 3 weeks before we got kicked out. And then it basically ended up being mediated by Bill Ussery through the President Clinton. I wouldn't presume to opine on these negotiations, but I think that what brings to mind is a few years ago, there were major labor disputes in many of the major league sports. I think this was probably around 2011, 2012. And what I observed at that time was that unless you were really half asleep, it would have been hard to have missed the notion of collective bargaining. Because I think one of the unfortunate things that has happened as the unionized sector has declined over the decades is that fewer and fewer people really know the value of unions, of union representation, of collective bargaining, what it meant for our economy. And so even the notion of collective bargaining is probably foreign to a lot of people. But I think that those high-profile labor disputes do bring attention, bring some understanding, just as much as I think the worker activism of the last few years, whether it's through Me Too or the Black Lives Matter, or whether it's the fast food workers fight for 15, or whether it's Uber drivers, all this active in the teacher strikes of the last few years has really brought a renewed understanding of the power of collective action to the public. And I see that as the real value.
Yeah, in the summer it was a real display of that with the NBA players just saying we're not going to play.
That's right.
We're just not going to play.
Yeah.
If things are going on in society that we need to raise our voice about, we're going to raise our voice, and we're not going to play a game. So, how did you view that situation? Was that a strike? Was that a walkout? Was that a wildcat? What would you sort of call that sort of activism?
As you know, Steve, the Washington Post sports reporter wrote a story just about what you call it. And as I recall, I remember discussing it with him, and I said, well, you could call it a variety of things. I think I came out by calling it a walkout.
Yeah.
You could call it a strike, I suppose. I think a boycott is a little bit of a stretch, except to the extent that you're asking the public to boycott the sport. But it certainly was a walkout. It may have been other things.
Right. It was fascinating, though, and it was a great moment. As you say, with the private sector, only 8% or so, 6 to 8% are in unions. You know, the reality of unions hits far too few people now. But when these kind of events happen, it does elevate the whole idea of collective action. So I want to pivot to talking about LERA. You are the incoming president, and I think you certainly have the opportunity to eclipse my record. In my year in 2005, I visited 20 chapters, and I was on the road.
Challenge.
I was on the road all the time, and my wife reminds me that I was on the road all the time. But now with this new technology, with this Zoom technology, it's actually relatively easy to pop into a place. So talk about LERA and what you hope to achieve. By the way, and I may get these dates wrong, I believe it's June 3rd to 6th, 2021, and it will be a virtual conference. It was going to be in Detroit, but we decided to do it virtually. So let's talk about that. But let me just remind people, if you have a question for Wilma, put it in the text in the chat box, and Patrick McHugh is going to come on in a couple minutes and lead the conversation through some questions that come in from the audience. We have a good group of people who have been listening. But talk about LERA in 2021 and what you hope to accomplish.
Well, I've already kind of previewed what I see as the unique advantage of LERA and how I would love it to continue to be and be more of a forum for exploring and debating these very pressing issues. We are at a very unique and uncertain historical moment. We have these separate but intersecting crises: the health crisis, the economic crisis, the racial justice crisis, the climate change, the climate crisis, and the democracy crisis. And so the $1 million question coming out of these intersecting crises, I think, is whether this is going to be a transformational moment. And there are those who say it has to be a turning point. We can't possibly go back to the pre-pandemic status quo, that all of the fault lines, all the inadequacies, all the weaknesses in our social compact, in our laws have been made extremely blatant, have been made very clear, and have been exacerbated by these crises. And the importance of the role of government in handling these kind of crises has been made even more clear. So that's one point of view. Another point of view is just the opposite, that we'll go back to where we were with pre-existing weaknesses and inadequacies, that people will just affirm their pre-existing beliefs, maybe even get further dug in, whether it's about government domestically or or global kind of governance ideas, that people will just not change their views. I don't know what the answer is. The election results might suggest that it's not going to be a transformational moment at the moment. I think to make something a transformational moment, there has to be political will. And how political will is created is complicated. I mean, some of it, I think, in the case of labor policy, is created by worker activism. A stronger worker movement, a stronger labor movement would be able to compel changes in the law of a more transformational nature. But I see LERA as a forum where these kinds of issues really can be explored in a safe context. And there are a lot of local and thought leaders amongst the membership here. So that, to me, that would be my goal, to foster that kind of debate and dialogue. And to go back to what you said earlier, to have more of an engagement by the business community and more openness of the business community to exploring these kinds of issues, a recognition that something isn't working.
Yeah, fantastic. All right, so Patrick, we're going to put our headphones on because otherwise we won't be able to hear you.
Great. We've got a couple questions for Wilma. Wilma, can you hear me?
I can.
Great, great. I'm going to take the prerogative to ask my question first, if I can do that. I may or may not be right here, but I believe you are the second woman to ever serve as chair of the NLRB. And I'm wondering, to what extent is diversity of board membership an issue? Do you think it's an issue? Do you think it could have an impact on board decision-making and processes? I mean, there's more and more research evidence suggesting differences in decision-making and so forth when there's a greater representation of women in decision-making bodies.
Well, I'm the second chair, but I'm not the second female. So there have been other women board members over the years. I don't know if you're just speaking of male-female diversity.
Yes, at this point, but.
So, I mean, during my tenure, I either was the sole woman or in the very beginning, I served with another woman, but there have been women in the past. What I would say about diversity is that, you know, I served for almost 14 years. I think I served with 16 different people, and every person was unique and created a different dynamic and created different opportunities or not for collegiality. So some people are much more able to work in a collegial environment, and some just aren't. And to me, that should be the critical fact in picking board members, people who are willing to work in a collegial environment, whether or not they ultimately agree with the outcome of a case.
Okay, thank you. I've got a question here. What are some of the most successful strategies that you have seen at this point in equipping workers of diverse ages, young, middle-aged, older, to successfully negotiating an ever-changing workplace, and, you know, thinking about, you know, changes in technology, for example?
So I assume by the word negotiate, you don't mean negotiating agreements. The questioner doesn't mean agreements, but just kind of navigating.
I think so. I think that's what the questioner is suggesting.
Yeah, well, that's an interesting question. I think technology is something, obviously, that may be a challenge for older workers, although I guess older workers are adapting, they're learning, and particularly if they have younger colleagues who can help them adapt. So they go back, in some ways, it goes back to your question about diversity, that I think the most successful way that people can navigate all these changes in the workplace is to have a diverse workplace, so that people can work collaboratively, can help each other to learn, whether it's new technologies or new ways of doing things. You know, I told Steve that I had to have a Zoom meeting yesterday with an executive board, and I didn't realize before I tuned in that I had to download an app. So there I was, all dressed up for a video conference. I was only on audio because I hadn't downloaded the app. So maybe if I'd had some younger colleague to set me up properly, I would have been more successful in navigating that. I'm being silly, obviously, but I do think that the diversity and the ability to work collaboratively, you know, remote working, I guess, is going to pose new challenges.
Yeah, I feel your pain. I feel your pain as I'm trying to navigate the chat and this discussion at the same time. I've got another question here, and here's the question. I'm not sure how we approach this, but what is the status of the UAW Department of Justice investigation?
That is something I'm not in a position to talk about, because in March I was named the UAW External Ethics Officer. So it's just something I can't talk about.
Okay, all right.
Let's actually ask the question a little differently, though, which is, you worked at the Teamsters for almost a decade and at the Bricklayers General Council. If you're thinking about worker voice and from the union side of things, what are some ideas do you think would be effective on the union side of representation to add more voice to workers generally? Said before, about 8% are represented by unions. There is some legislation to say put workers on all boards. Do you think there's a role for unions to do training for people to be on those type of boards, for example?
Absolutely. And,
Yeah.
For one, yeah, I mean, if that came to pass, it certainly would be something unions could be involved with. I think training opportunities in general that unions could become involved in local areas or in states in apprenticeship programs, apprenticeship and training more than they do working with local community colleges. I see that as another avenue for area labor management committees, something that unions could do, whether it's adapting to new technologies or learning job skills or et cetera.
Yep. Okay, Patrick?
Yeah, I've got another question here. One is regarding employee status of student employees and graduate students. And it seems as though that's been a ping pong decision back and forth. Do you ultimately see this going to the courts and then the Supreme Court making a decision, or are we going to continue to see a ping pong of this employee status of student employees?
Well, I suppose it could at some point go to the court. The most recent iteration of the board was the Columbia University decision during the Obama administration, finding the graduate teaching assistants to be employees. I can't recall at the moment whether Columbia ever filed an appeal on the Second Circuit Court of Appeals and then withdrew it, or whether it never filed. I just don't remember it, but it ultimately recognized the union. When President Trump was elected, I believe that the unions pretty comprehensively, if not entirely, withdrew any cases that might have been pending at the board that would have given the board an opportunity to reverse Columbia. What the board did was to propose a rulemaking, which presumably would have reversed Columbia. It has gotten comments on that rulemaking, but to date, there has been no final rule. So query whether that'll happen in the last days of the Trump majority, I really don't know. But it is certainly an area that would be ripe for reversal once there is but did I say Trump? Did I make a mistake? Yeah, yeah, I meant during it. I don't know whether that rulemaking will come out during the remaining days of the Trump majority, but it certainly would be an area that would be ripe for reversal by a Biden majority. It's if some university wanted to contest a union win, I assume they would go to the Court of Appeals. So it could one day, although this has been, as you say, flip-flopping for a long time now.
Got a question here about employee ownership and a question as to whether employee ownership leads to increased worker power. If not, why not? If so, why?
Well, many believe that worker ownership does give employees not only an equity interest in the business, but if it is structured that way, it gives them far greater say over their working conditions and their compensation and their investment. So it has the potential, yes, to increase worker power. Whether it always works that way, I gather some ESOPs, the employee stock ownership plans, give a fair amount of governance to employees. Some really don't.
Right.
Steve, you can probably speak more to that.
Right. And really, the devil is in the detail. And in my experience, there is even more of a role for a union in an employee-owned company. May sound counterintuitive, but the idea that all of a sudden all the workers in an operation will think like, short-term capitalists doesn't make any sense. Workers have the longest term interest of anyone in the firm. And so the union's role in a worker-owned enterprise is to make sure that all the workers' voice is aggregated and bargained over. So it's a tricky area. And most ESOPs, I would say, are set up as a tax issue, not so much as an empowerment issue. So that's a whole issue.
But of course, there are different forms of employee ownership, including co-ops. And I want, there are these issues come to the board once in a while too, involving employee ownership. And I once dissented in a case involving a driver of some kind of a car in New York City where it was a co-op owned company, and he wanted to unionize and he was fired. And the majority of the board said that because workers each had one share and one vote, they therefore had the majority power over managerial decisions. So they were managerial and not employees covered by the law. And some people said, well, why would they need a union anyway? And I dissented on all those points.
Good.
Yeah, it reminds me, I've done some research along with Joel Kutcher-Gershenfeld comparing ESOPs in unionized workplaces versus non-union workplaces, and they do look different on some different dimensions. We've got another question here. Do you see the potential for a federal unfair dismissal law to protect all employees with due process mechanisms, with resolution through mediation and perhaps then a tripartite board?
So in other words, doing away with the at-will employment doctrine. Some people believe that if there were only one piece of legislation you could get that would help, it would be that, to undo the at-will doctrine. I'm not sure that if I had my choice of one piece of legislation, I would go with that. But I would say that if it were enacted, it would have, it would be very beneficial.
Hmm. You kind of begged the question there about an alternative law that you might see. So
there are too many choices.
Too many choices. Okay.
Yeah.
Patrick, let's have one more question.
One more question. Okay, here we go. Do you think it would be better, and this kind of gets to the issue of, I guess, changing labor law, be changing board processes in some ways. But would it be better to have a specialized federal labor court and kind of move away from the kind of current NLRB system that we've got?
I think there's a strong argument that can be made that given the difficulties with the appointment process that we've witnessed over the years, the polarization, it could, I suppose, similarly infect a labor court with the appointments. The board, of course, has the years and years of expertise with this statute. I think there are arguments that can be made for both. I think the likelihood of that happening is probably slim to none.
Wilma, we're going to let you have the final word before I turn it back over to Patrick for some housekeeping items and announcements about our future programs. But this has been a great conversation, and thanks for joining us. I'm done with PowerPoint. So, I hope that the audience enjoyed the more informal conversation. We couldn't have had a better person to start this off than you. Your career is just a great example to people to follow. So any last closing words about your hopes and desires for labor and labor law?
Oh, well, I probably made those quite clear. Let me instead say that I appreciate the opportunity to have been here. I much prefer a conversation than just either PowerPoints or a monologue. I think most adults find it easier to pay attention to a conversation as well. And I thank everyone in the audience and hope everyone is managing through this very strange and long stretch.
Yeah, great. Can I ask you also could you make available some of the articles you referenced and that we could post up on our webpage?
Sure.
Okay, fantastic. That'd be great. Patrick, I'm going to turn it back over to you. And we've got some good programs in December and in January. And actually, I hadn't told you this, but the January date is going to be different than what we originally planned. somehow neglected to realize that January 20th is Inauguration Day, so it's probably not the best day to have a conversation like this. But so we're going to find another date for the January presentation, which will be with Christy Hoffman from UNI Global and a colleague of yours. Patrick.
Well, first of all, just thanks so much, Wilma, for taking time to spend some time with us and sharing your tremendous experiences and insights. And Steve, what a great moderator you've been here. Thanks so much for helping coordinate this. Emily, thank you as well, and Bernadette. Just as Steve said, we got a great program coming up December 16th. We got Mark Hyman, who's currently the director of the Povich Center for Sports Journalism, and he's actually going to be doing an interview with Adam Richelieu, who works for the NFL Players Association. So it should be a really interesting session, and please join us. We'll be sending out announcements about that coming up. So again, thank you very much for joining us. This was a wonderful session, and stay well, stay safe.